Motherfucker one has you. I think so. I don't know which one though.
Let's proceed.
May it please the court, my name is Morris Cahalan. I represent the Springfield Public Schools. This case is here on further appellate review from a decision of the appeals court. In July of 2004, the plaintiff, who was a school counselor in the city of Springfield, was indicted in federal court for conspiracy to commit bribery and theft and receipt of illegal gratuities with respect to herself and members of her family, and the assets involved were those of the Springfield Housing Authority. Her father was the director of the authority. Among other things, the indictment included the allegation that she had $237,000 of cash in her attic at the time she was arrested. Shortly after that, in August of 2004, the superintendent of schools suspended Ms. Serrazina under the provisions of Chapter 268A, Section 25. About 2.5 years later, the plaintiff and the United States Attorney executed what's called a pretrial diversion agreement. And that in that agreement, the plaintiff states that she acknowledges and stipulates to the accuracy of her responsibility for certain conduct, which included receiving items and services from her father that belonged to the Springfield Housing Authority.
Section 25 is very specific about a finding of a conviction or finding of guilt, correct? Uses the word guilt. Doesn't it?
I'm not sure.
In other words, part of your argument is that we should treat the diversion, the agreement that Ms. Serrazina entered into with the United States Attorney as a determination, as the equivalent of a finding of guilt, such that she would not be entitled, that she would not be entitled to suspension pay. Isn't that sort of?
Yes, that is one of our arguments, and we're relying on primarily the Brittle case, where I think the court said that we cannot be completely and absolutely literal about this statute.
Yes, but I mean, there's a huge difference, isn't there? I mean,
well, there's a difference in the facts of the case. However,
and
in
he was
this
convicted
circumstance,
of the crimes that related to that for which he had been suspended.
Well, in the agreement,
Is the point?
in the agreement, she agrees to restitution of $20,000.
I know that often happens.
I'm sure it does, but it looks, sounds, feels like the same thing as a guilty plea, and that's something that should be taken into account.
But there are two differences. One is there's no finding by a court, as there would be with regard to a guilty plea, even with regard to a quaff, and the admissions that the person made, it includes no admission of intent to commit a crime. It simply say, I accept that I am in possession of things which I received from my father, but there's nothing there which says I understood that those were stolen from the Springfield Housing Authority.
And no denial either. It's a very carefully worded agreement, and part of the problem here is that this is two different entities from the city who are entering into that agreement. The U.S. Attorney isn't representing the Springfield Public Schools or the Commonwealth. They're entering into their agreement, and we don't have any input on that. She gets to carefully word it in such a way as, sure, it looks like she's essentially pleading guilty, but you could pick at the words and say, well, maybe she's not. But in any event, even if all of that were not the case, the appeals court ruling here is what we have challenged is something quite different, in that the court has taken Chapter 71, Section 42, and Chapter 268A, and treated them as if they were dual remedies that a teacher in this circumstance could use.
Let me ask you this. If Ms. Serrazina had sought in the arbitration to be paid for the period of suspension, what would the city's position have been?
Oh, I don't think there's any question she would have been entitled to seek that remedy, and I don't think at any point the plaintiff has ever said that she wasn't entitled to seek that remedy. It is a completely standard employment law and arbitration remedy.
Entitled to seek it because she hadn't been found guilty, right?
Pardon?
I mean, because she was reinstated, right?
Agree with?
She would be entitled to have it because she was reinstated as a teacher, something that you didn't challenge at all, correct?
Correct. If she had sought back pay in the arbitration, and if the arbitrator had issued the same ruling with a back pay remedy, she would have been entitled to all that money. But she didn't do that.
Even though, let me just ask you this, though. Even though, presumably at the time that she was suspended, she was under Section 25, she couldn't be paid. Or anyway, the city had absolutely every right not to pay her while she was under federal indictment, right?
During that time period, sure.
So,
But then she was terminated, and that was before the dismissal of the criminal charges, which the appeals court, at least on the first page, incorrectly reports. She was still under indictment at the time she was terminated, and at that point, Chapter 268 doesn't matter. It's not a termination statute, which the appeals court agreed with.
And in fact, the appeals court said she doesn't get any back pay for the period, the post-termination period, correct?
Correct, but that requires the court to conclude that after the legislature sets up a comprehensive remedy under Chapter 71 for the dismissal of a school teacher, which includes the right to full back pay, which specifically lists the kinds of damages or remedies that you cannot get, which doesn't include back pay for a suspension period, that we're just going to throw the idea of an exclusive and comprehensive remedy out the door and have two different pieces of litigation going on.
You're omitting the fact that Section 42 says, except as otherwise, it's got language in it about other statutory provisions.
Other statutory remedies for termination. But everyone agrees that, with the exception of other remedies provided by statutes, the remedies provided hereunder shall be the exclusive remedies available to teachers for wrongful termination.
Well, she's not after wrongful termination. She's trying to get back the money that she was paid. She wasn't paid when she was suspended.
Well, I don't think that argument would make sense in a circumstance where you can go to the arbitrator and get all of that back pay. And it is, I think, so axiomatic you will not find a case that in employment law where you have a back pay remedy that whoever the deciding authority is, whether it's an arbitrator or a court, if you were suspended, which often happens upon suspicion of something, and not paid, and then terminated, when you seek back pay, you get the back pay for the whole period.
Am I going to find a case where somebody's been suspended under Section 25?
Well, no, because there is no other case like this. I mean, it's unquestionably a different situation, but the appeals court agrees it's not a termination statute. So once this teacher is terminated, and she's still under indictment when she was terminated, Chapter 268A doesn't matter, even if one ultimately concludes that under 268A this wasn't a guilty finding. It doesn't matter because she had the right under Chapter 71 to seek that full remedy, and by going to the arbitrator, and now arbitrators will frequently, in labor and employment cases, end up with a ruling where they divide the remedies, where they will say, well, I'm going to reinstate you, but I'm not going to give you full back pay. I'm going to say you should have had a suspension for X amount of time. So you go to the arbitrator and you say, I'm waiving all of my back pay. Well, you've improved your chances of winning that arbitration as a practical matter to a considerable degree. But the legislature says specifically, I mean, they put it in Chapter 71, this is the exclusive remedy. And if it's the exclusive remedy, and the plaintiff chooses to do that for what may be a strategic reason, we don't know, but chooses to do it and improve their chances of winning, they can't come back with another piece of litigation under another statute.
What was it that she represented to the arbitrator about why she wasn't seeking back pay?
She said she was going to seek it in another forum.
So she didn't really say she wasn't going to seek it.
Well, that's true.
So what you're suggesting is that she was trying to use this to her advantage in order to get the arbitrator to say, well, all I'm deciding then is whether to reinstate her. So she's waived her back pay claim, so I don't have to worry about that. But that's not really what she said at all. What she said, you just told us, is that she was going to seek it in another forum. So the arbitrator would have no reason to think that she wasn't going to seek it at all.
Well, excuse me, I didn't mean to imply that the plaintiff had told the arbitrator,
Okay.
I'm doing this because I want to improve my chances in front of you. And no, I know that didn't happen. I'm saying that as a practical matter, when you go before any tribunal and you're asking for less, it's a lot easier for you to win. And in a circumstance where you just...
Did the city argue before the arbitrator, look what she's doing, arbitrator? She's trying to improve her chances? I mean, you were free to, the city was free to, or the school committee was free to say, you shouldn't let her, you should make her waive it?
Well, if representing the city in the arbitration and a party is waiving, in effect, or declining to seek a significant remedy that they might otherwise win, I'm not going to object to that.
Well, you might want to say, since she says I'm pursuing it in other forums, you might want to say, no, this is a waiver, mightn't you?
Well, I suppose that one could have said that, but that's a strategic dilemma that shouldn't affect the outcome of the case, because from the city's point of view at that moment, why shouldn't I accept the fact that this party has decided not to seek a very substantial remedy against my client?
In this forum.
In this forum.
Pardon?
In this forum.
In that forum. Now, if her position is, and she stated, well, I'm going to seek it in another forum, that doesn't mean that I have to concede in any way that she's entitled to it under circumstances where the statute itself, both the Superior Court and the Appeals Court agree, is not a termination statute. It's not a remedy for termination.
But I thought your argument was that she's not entitled to it because she waived it.
Well, I agree that she waived it.
No, but isn't that your argument? That that's the reason that she can't seek it under 268A, Section 25, because she waived it, because she didn't seek it in the Section 42 proceeding?
Well, it amounts to that, but I think the actual argument is that Chapter 71, Section 42 is an exclusive remedy, so that once that case has been completed, once it's done, and you've gotten all you are going to get or can't get, then you can't come back under another statute, which no longer applies because you are a terminated employee, not someone who is under indictment who then came back. In effect, once the employee is terminated, they have a full and complete remedy under Chapter 71.
For the termination.
Pardon?
For the termination.
Well, that rationale, and it's hard to tell whether the appeals court seems to be saying it, but they don't say it explicitly, that somehow she couldn't get the back pay for the suspension. There's just no basis to believe that. It's completely traditional in arbitration law, in all employment law. If you are suspended without pay for whatever reason and then terminated, and you bring a case for whatever it is, discrimination or breach of contract, there was no question that you were entitled to get all your back pay, and that a back pay remedy means to make you whole. That's a common term, and certainly in arbitration and in labor law, to be made whole. And if you were to exclude the suspension period, you would not be made whole. And obviously the legislature was using that term, back pay, and then created a specific list of exclusions of what kinds of remedies or damages you could not get. And it didn't include suspension periods where you were not paid. So if we're going to accept what the legislature did in creating an exclusive remedy, then we have to accept the fact that this case ends with the arbitration, and the appeals court's action now creates a situation where you've got two pieces of litigation about the same course of conduct. It all regards the same facts, the same course of conduct. This is not where she was suspended for one thing and terminated for another. It's the same thing. They're creating a situation where you have two pieces of litigation over the same set of facts. That's always disfavored. The best way to read the statute is that where it says exclusive remedy, it is an exclusive remedy. And the appeals court, without explicitly saying so, seems to be implying that it wasn't a complete remedy, and there's just no reason to believe that that's not the case. Chapter 71, Section 42 lets you get reinstatement. She did get reinstatement, and under this statutory setup, the case should have ended right then and there.
Thank you, sir.
Good morning, Your Honors. Timothy Ryan on behalf of the plaintiff appellee, Maria Serrazina. Chapter 71, Section 42 comes out of the Ed Reform Act of 1993. And the whole purpose of Section 42 was to depoliticize and streamline the process for teacher terminations. Under the old system, the school committees of the various cities and towns would have to make those decisions. The new system gave the superintendent and the school principals the right to terminate a teacher. And it took it out of the town hall and at the superintendent level where it should be. As part of the compromise, the legislature gave the teachers a limited window to file arbitration, 30 days. And if they don't file that arbitration, they've lost their job. And it set forth specific ground rules by which the arbitrator would review the decision to remove a teacher or not. And it set forth specific limits as to the authority by which an arbitrator can award. And I fundamentally disagree with my brother. I fundamentally disagree with the position of the city of Springfield that at an arbitration under this specific limited statute, an arbitrator has the right to decide a employment discrimination case as part and parcel of the termination.
I'm sorry. What we have here is a teacher who was suspended because they were indicted. And then they were subsequently terminated.
That's correct.
Based on the same conduct. And you have a statute that provides if a teacher's terminated, they go to arbitration, and they can ask for back pay. Presumably, that back pay would cover the period of suspension before termination as well as...
Well, my brother argued that the statute covers these broader claims, that anything that's pending between the teacher and the district is subject to arbitration. And I fundamentally reject that. There's nothing in the case that says it. Because, for instance, Your Honor, the legislation does not allow the arbitrator, if it's a discrimination claim, to award emotional distress damages, to award attorney's fees, which are two fundamental provisions of a discrimination claim.
But it does allow the arbitrator to award back pay, which is what we're talking about here.
Back pay measured, I submit, Your Honor, to the date of the termination.
So you're saying that if you had gone to that arbitration and say, Your Honor, my client was not only wrongly terminated, but also deprived of the money that she is entitled to because that case did not result in a finding of guilt, that the arbitrator would say, I have no authority to do that?
I have no authority to decide suspension back pay. That's Chapter 268A, Section 25. There's nothing in the legislation, Your Honor, that gives the arbitrator the right to make awards pursuant to that.
Are you focusing on the language that focuses in section, in that Chapter 2, in the event of reinstatement, the period between the dismissal and reinstatement shall be considered time served?
That's correct, Your Honor.
Because, so that's termination rather than suspension, and that's a separate.
Suspension is a separate, distinct statutory right. And in this case, Your Honor, what we have is we have 3 years and 2 months of suspension pay claim, and we have approximately 6 or 8 months from late October through the balance of the 2007-2008 school year.
Did the teacher here ask, in proceeding to arbitration, state that she was going to be seeking only the suspension period back pay and was waiving the period from dismissal to reinstatement, or was she seeking the suspension period back pay as well as the period from dismissal
No,
to
Your Honor,
reinstatement?
there was nothing made, there was no proffer made at the arbitration. The appeals court...
Either period.
For either period. The appeals court said that by virtue of that, there's no termination period damages.
With the view that if there had been, that's where she would have made that claim.
Yes,
She would have had to have made the claim because the suspension statute only deals with suspension.
yes.
Okay.
On that, and the appeals court believes that the argument was highly illogical, but I'll make it nonetheless here. She's suspended up to the date of termination. The termination happens. It's reversed in July of 2008 by virtue of the arbitrator's decision. Under the Brittle case, Your Honors, I submit that the reinstatement of her as an active or as a teacher within the system does not lift the suspension. That if she comes back to the city, she comes back subject to the same conditions on which she left. And while the Brown versus City of Taunton's case says that termination ends to the suspension, where she comes back to work, I guess I'm not quite sure that the reinstatement terminates the suspension. But that appears to be what the appeals court said, and that's how they...
It's really not, I mean, if I understand correctly, that's an argument to be had with the city about how much they pay her back for the once the suspension is removed. It's not it wasn't before the arbitrator, and it wasn't really before the appeals court, was it?
There's some findings. The appeals court made a finding on that, and that's why they said
The
there's no...
appeals court said that you had to go, your client had to go, if she wanted pay for
Termination.
post-termination, she had to be before the arbitrator.
And it was our opinion that, and the appeals court corrected us, that since the suspension was at all times in effect, that the suspension covered, but so be it. We'll accept the appeals court.
But didn't your client at the arbitration say that she was not going to be pursuing back pay in either respect?
No, it was just a general, we are not pursuing it in this venue, Your Honor.
Okay, so to the extent that the arbitrator could have, on your theory, given her back pay to the date she was terminated,
Yes, he
the
could.
arbitrator didn't do that.
That's
And
correct.
isn't what the appeals court did to say, well,
That has been
you
waived.
can't seek that under Section 25?
Yes, they said that argument or that claim has been waived.
Right.
But we submit that Chapter 7142 is not an exclusive remedy, and we also submit that there's nothing in the paperwork before the court that suggests that the pretrial diversion agreement is the legal equivalent of a plea or a finding of guilt. And for those reasons, we submit that she is entitled to the suspension back pay for the 3 years and 2 months in question. Thank you, Your Honors.
Thank you. We'll take a brief recess.
All right.